Good morning, everybody, and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. We are hoping to get some video of this motions hearing for Oscar Solis, for Florida versus Oscar Solis. So right now, it doesn't look good. Nobody is streaming it, covering it. So we're going to, in the meantime, just sort of play what we have. We're going to just sort of do a deep dive on him. If something appears and pops up, we'll grab it. But right now, nobody's streaming it. Nobody's showing it. There's no Zoom link. There's nothing on YouTube. So unfortunately, it does not look like we'll be able to, at least right now, we won't be able to see Oscar's hearing today, but we do have some backstory, so we can actually do a little bit of a little deep dive on this guy and the person that he murdered, which is Randall Cook. So just briefly, before we get to the press conference and the hearings that we do have of him, so this was April of 2023. So Randall Cook, he's 59 years old. He was an Uber Eats driver. He made one last stop, right? He was texting his wife. He's like, I got one last stop. And this all happened in Holiday, of all places, Holiday, Florida. So he had one last stop. He's delivering food, Uber Eats, to this residence. And unfortunately, the person that was living there was Oscar Solis. And he's 30. He had just recently moved to Florida. He had just served 4 years in prison for burglary and assault. And he also has ties to the M13 gang, which basically is Mara Salvatrucha. It's a combination of Spanish and slang. So Mara is Central American slang for gang or group. Salva is short for Salvadorian. And then trucha is slang that can mean alert, clever, sharp. So it's apparently it's used to be watchful or street smart. So Mara Salvatrucha roughly translates the Salvadoran gang or the Salvadorian street smart group. So April 19th, 2023, Cook was seen making a delivery to Solis's residence. Surveillance footage captured Cook approaching the house before the camera was turned off. Later, investigators discovered Cook's dismembered remains in a trash bag on the property, along with his wedding ring and car keys inside the home. Now, Solis has been charged. We're going to watch a hearing of that. He's been charged with first degree and abuse of a unalived person. Prosecutors are seeking the death penalty, citing the heinous nature of the crime and Solis's extensive criminal record. So he has a past record, very violent, so that's why they're seeking the death penalty now. He's pled not guilty, and I do believe we have a trial date, so we'll get to that. But before we do, what are you guys saying? Anything? Good morning, Anja. Good morning, Fala. Equinox, hello to you. Hello and good morning. Equinox, he's a big guy. We'll see him in action, not in action, but we'll see him walk in. He's a big guy. Hey, Baka, good morning to you. Glad you could make it. All right, so let's get to, first of all, we'll start with the news conference, all right? So this is a news conference. This will give us a little bit of history on him. So let's get to the news conference. And we have a couple things we can show you guys. So we'll start with the news conference. And we do want to cover this. So when he does go to trial, I hope they show this, because this is definitely something I would like to cover.
Everybody good?
We are.
Good. Good. All right. Good afternoon. First and foremost, our job is to protect the family right now. The dignity of this case, we want to, well, dignity for the family, dignity of the victim, we want to make sure we protect that. I'm not going to get into how gruesome this case was. There's no need to. This will live on for infamy, and this family have to live with this. And so to them, our prayers are with you. As we said, our victim advocates are with you. They will stay with you. Whenever you need them, just call them up. They do an outstanding job. To the detectives, to the forensics unit, the ME, everybody who was involved in this investigation, I want to thank them personally, because it was a horrible scene for them out there for several days. It was tough. And for the neighborhood that had to have, with us being out there, I know it's a lot on you too. So I just want to get that out there, because these are just a gruesome case, and this is horrible. And I'll get a little into it further, but it's just one of those things you can never answer the why. And that's what I feel horrible for the family for. So our victim was an Uber Eats and DoorDash driver. I mean, you watch the video, he was a guy just like everybody else, just trying to make a living for his family. And on April 19th at 2:30 p.m., he had dropped his wife off, and he started doing his deliveries. His wife and him were communicating via text. At around 6:43, she sent him a text. He responds back and says, yeah, this is basically my last one. I'll be home soon. And he was right around the corner from their house. At 7:13, she sends a message, but there was no response back. So late April 19th into the 20th, she reports him missing. Our patrol goes out. They start doing an investigation. Wasn't a few hours later, they hand it off to the missing persons unit. Missing persons unit then takes over the case. They actually, later that morning, our missing person unit reached out to Uber Eats, and they were able to provide us some information and his last known GPS coordinates. We post this information on our social media, hospitals, fire rescue, FHP, databases. We kept reaching out to find out, could he just been missing? Did something happen? That was he in a crash? So we're just trying to figure those things out. The GPS showed that he had gone, his last known location was 3438 Moog Road, which is down Holiday. Detectives went to the house, walked around it. There was nothing really suspicious on out there. Nobody answered the door. And so there's actually a body of water across the street. They looked over there to see if maybe something happened. There was no evidence of anything going on. But we kept following up on leads. On April 21st, we actually go back to the house at 3438 Moog Road. At that time, we were able to make contact with the roommate of the suspect. The roommate was able to provide us video, and you can actually see the victim walking up to the house to deliver food, but the video cuts off at that point. You can also see that that was around 6:45 when the video cuts off, or 6:55, right there when he was walking up to that house. You actually see on the video that the following day, so that was the 19th when he delivered the food. You actually see on the following day, on the 20th, the suspect, Oscar Solis, was carrying trash bags with another individual, and you can see them carrying these trash bags around the side of the house. So our detectives did the right thing. They asked for permission to go through the trash bags, to go into trash bags. There was several of them. And unfortunately, what we found inside of some of those trash bags was human remains. So at that point, we held the scene as a crime scene. We were waiting for Emmy, the medical examiner, to come out. Forensics came out. But we were also able to make an arrest on Oscar Solis. He was arrested at that point for failure to register in Pasco County as a felon and violation of parole. He had been in parole in Indiana. He had just moved down to Florida back in January. And so you'll hear his background is a very violent individual. But we were able to make an arrest for those charges immediately. And so we knew at that point there was no public threat out there as to what happened. But for us, and this is what takes so long. And I wish we were like those TV shows where we can solve everything in an hour. We can't. Our job at that point, first and foremost, is to make sure that there's no more public threat. We took care of that. Our second issue at that point was we had to identify the victim. And so the following day we were able to do that. But the other part too is we have to build a case. Because I know for many people, everybody wants things done immediately. I just want a solution. I want this done absolutely like within seconds because we're used to that with Google. But the problem is it doesn't work that way in the real world with cases. And if we as a sheriff's office don't do everything we can from a forensic standpoint, from an investigative standpoint, hand it off to the state attorney's office, and they're not able to bring justice to the family, then we failed through the pipeline. So we can't fail. We have to do everything. And if it may be slow, it's slow, but it's going to be done right. And so that's the one thing we just want to make sure everybody understands out there is that we couldn't give those updates because we did not want to hinder the investigation. After we were able to identify the victim and notify the family and have victim advocates out there, we were kept through the process. And then last evening, on April 24th, we arrested Oscar Solis for felony murder in conjunction with a robbery because we were able to find the victim's wedding ring and car keys in another room in the house outside from where we believe the homicide occurred. And so a couple of things real quick. Talk about Oscar Solis. This guy's he's affiliated with MS-13 from Indiana. Like I said, he just came down here from Indiana like a month or two ago, 2 months or 3 months ago in January. His charges before, he had been battery, burglary, possession of stolen auto parts, drugs, resisting law enforcement, other burglary charges, home detention placement, burglary, battery on detention staff. He supposedly stabbed somebody several times while he was in prison in Indiana. So you're talking about a very violent individual that Indiana released and sent down to Florida. He came down to Florida. They released him on parole. And so unfortunately, now we have a hardworking guy, a loving husband, who's no longer with us because this violent individual killed him. Our call for action we're asking right now is that there are several pictures. These individuals, and I'll tell you, if you're one of those individuals or you're the parent or guardian of one of these kids, it looks like they're young adults, they're not in trouble. We just need to know who they are. Can they come forward information? They were actually in the house about an hour before the homicide occurred. So if anybody has any information, please come forward. As I said, you're not in trouble. We just need to keep building this case because we in Florida will bring justice for this family. We'll ensure, through the state attorney's office that, the family realizes that we did everything we can because this victim, I go back to it's sad. It's horrible. And the one thing, us as a command staff, we get these updates on the homicides, we get information. And as I start the press conference, and I'll tell you this, I kept asking, what's the connection? Because unfortunately, a lot of times in homicides, there's a connection there. Sadly, we know domestic violence is horrible. We know that, there's drug addiction, drug dealers that will shoot each other over drugs and, beefs over gang or other issues or business partners that are mad at each other. There's something that you can say, okay, there was passion, there was anger. This was absolutely a horrific crime of passion. This person, you always say the word evil, but this is demonic. This individual what he did was demonic. But at the same time, we couldn't answer the question why. What the relationship? There doesn't appear to be any relationship. All it appears is that there was a gentleman who was working, was doing his last delivery of the night, and this person killed him for no reason. And he took him away from his family. So please, if there's anybody out there, any other information, please provide it to us, get it to us. We're building up this case. We're working with the state attorney's office, but we're going to ensure that in Florida there will be justice. So with that being said, any questions?
Those kids, do the roommate know who they are?
I'm not sure. I'll let one of the detectives, if you guys know if they...
Name's Roger Middleton, Middleton. I'm a detective in the Major Crimes Unit. The roommate does not know any of the children, but says there's several children that come in and out of the home often.
Do you expect, are you concerned that those children are alive or not?
There's no indication anything other than they just were visiting the home.
And the guy, he just moved here, so does he have any family here, the suspect?
His father lives locally, and we've been in contact with him.
Were he the suspect and the homeowner the only two that lived in that home, or did they rent, or who would those kids be visiting?
It's unclear. It's where we're wanting to locate them and speak with them.
But is he the homeowner, or do they both They both renters.
The home is rental.
So are there any potential charges against the roommate or any other individual who may have known anything or participated in this?
Well, that's we're going to keep building the case, but this is the spirit. Anything that the detectives found out that anybody knew anything, even the other individual who's taking the trash bags out, just somebody who the father had sent over to help him. You know, the father had somebody that would go over to drive him places, would take him places. So that was the person. Just somebody's like, hey, I'll help you move the trash. The roommate actually made a comment to the detective saying, I was surprised the guy actually took trash out. Like, guy finally did something. The other information is that the suspect may be a gamer. So maybe that's why these other kids are over there. They're hanging out at the video games, not sure. But these are other things. This is why we need to figure out some of the information. He is, how old was he? 30 years of age.
And we don't know how old these kids are.
They could be 18. They could be adults. They could be minor. That's what we don't. So we don't know.
Is there any relationship between the two roommates as to why this guy comes from Indiana and ends up in that house?
So the house is leased to the roommate and this gentleman's father. And when he came down from Indiana, his father moved out and allowed Oscar to move in.
And the roommate, he wasn't home at the time of any of this. Did he say where he was at? Or?
He was not home, and it was corroborated.
Are you guys aware of any MS-13 activity that this man was affiliated with other members of MS-13 in the area?
I don't think. Nothing. No.
And with him not having registered himself as a felon, what are the procedures in place to catch people that aren't registering themselves when they move states?
So that you can register with the Department of Corrections in the state of Florida, but you also have to register as a felon within the county. So he was not registered in the county as a felon.
Correct, but what's the policy in place to follow up that people are adhering to the law in that regard?
So it's a difficult thing. People, I mean, we're a big state, we're a large state. People can register with DOC, but we don't know if they're in the county. So it's a very difficult task, and it's one of those things that it could be through a traffic stop. It could be through an arrest like this, interaction like this. That's when we find out that they didn't register.
Like a crime has to be committed before unless he's registered.
Or an interaction. He could have went missing. And when we found him, we looked him up and said, oh, he failed to register in Florida.
What's it been like working with Uber Eats and different delivery companies like this? We've seen a lot of violent incidents happening to delivery drivers, and how are those relationships?
So when the sergeant was able to notify his liaison at Uber Eats, they were very quick to give us the information. I'd say it could have been Uber Eats, it could have been DoorDash, it could have been any delivery. I don't think this guy cared. This guy is supposedly, from the information I got, I said a lot of this information is so preliminary. The father ordered food for the son. He could have ordered anybody.
The father had no idea what his son was planning. He's not involved today.
I feel bad for the dad. I mean, it seems like indications that the dad was just, he had a son that he was basically helping throughout the way. And the information is he just ordered food. And so that could have been, I don't want to go through every company because then they'll get all upset, but it could have been any company out there that it could have been delivery for. And that would have been the person. But that's what I said. This is just a random person. It could have been anybody. It could have been a member of religious faith that was knocking on doors. And this person just yanked them in and killed them.
Sheriff, you mentioned that you didn't want to go into the graphic details of this. I understand that.
Yeah.
But how could the roommate not know that something had occurred if it was that bad inside?
Not much want to speak on it, still
Yeah.
ongoing, but he wasn't home at the time. And when he came home, it was night, and then the detectives were out the next day, and he had actually been with his family away from the home until we made contact with him.
How's the victim's family doing right now?
I know our victim advocate's been working with them. I don't know exactly. I can only imagine. I can't imagine. But that way I can't imagine what they're going through. The heartache, the heartbreak, the fact that, she's texting him, she's nervous. And honestly, you're talking about caring. I mean, she kept texting him, and then she notified immediately, hey, what's going on? Where's the, I mean, she did everything she could. Evil just came. I mean, this person was just demonic in what he did. And you feel horrible for that wife. And just pray for him.
Most of these delivery services, ring the doorbell and leave it at the door. Is there any indication as to why there was an interaction between the two, and did he forcibly bring him into the home?
So the camera shuts off. So that's the sad part, is that when you watch the video, and the detectives, it says part of the investigation, but when you watch that video, he's literally standing there just waiting, and he probably was thinking to himself, am I at the right house? Because nobody was answering. But then the camera goes off. And we don't have the video of him getting taken inside.
Why does the camera go off?
It's part of the investigation. I mean, we all have common sense. We can all believe and have our understanding, but until it's 100%, this is exactly why. Look, you all can say those things because in court it doesn't matter, but if I say something, that could be brought up and I can't say it.
Did the detective find any blood in the house at all?
Sorry. That's all right. There was a substantial amount of evidence inside, but it's still being wrapped up and completed.
Speaking of evidence, when you guys said you went out there, one of the times you also looked at a body of water, like a pond or something. Did you find anything in there?
They were out the day prior on the 20th just to look as far as the missing person investigation, just based on the GPS location of the victim.
For sure, but did you find anything in
No.
the water? You did not find it.
Not that day, the 20th.
There's also like rumors that possibly as part of that gang initiation.
There's nothing evidence that would lead to that, but the question about the body of water, I'll go back to that. So basically what they were looking for was tire marks, something that would have shown that somebody entered the water. A lot of times the missing person calls, we have to, anytime there's a body of water, you constantly are looking, whether it's a person with dementia, a child, somebody suicidal, you always are looking around if there are any signs. So until there was actually evidence to say, okay, further, then we really sent people in that water to start searching. But there was zero evidence of anything that somebody was in it.
The victim's car, was it there at the property?
Who?
The victim's car?
The victim's
The victim's car, yeah. Was it?
It was located abandoned just like a third of a mile away from the home.
Is it ever too soon for you to call the sheriff's office with concerns of someone missing?
No, I mean, that's one thing. I can imagine, because of police shows, everybody thinks that our biggest calls for service are, robberies, homicide, all these. A lot of our calls for service are missing people. That's the majority. That's why we consistently post them out there. And so we tell people, hey, look, we're going to do everything we can because we know that's somebody's loved one. Why do we have one of the largest canine units? It's because our dogs are consistently out there searching for missing people. Our bloodhounds, our live-fire dogs, our cadaver dogs, we're consistently out there looking. And so that's one of the biggest calls that I know we as a sheriff's office, that's one of our larger calls. I can imagine for all law enforcement, it's people go missing. And so how do you find them? What do we do? So that's why we take it extremely seriously. But as I go back to that point, it's never too early. From our standpoint as investigations, we will say, hey, look, these are the steps that we usually take. Whether somebody ran away, whether it's an adult, what we can and can't do. But at the same time, is we know that's somebody's loved one. And so when being somebody's loved one, it could be one of our loved ones. And so we take it extremely seriously. But we have our procedures in place. We have our plans in place. And so it could be that kid that ran away 100 times, or it could be that person that went missing the first time. We take them all very seriously.
You mentioned that the keys were found inside the house, the keys to the car.
The keys.
Yes, sir.
Yeah, the keys. I'm sorry, the keys to the car. I knew his ring was, but I knew the keys were, yes.
But yet the car was found a third of a mile or so away. Do we know who may have moved that car? Do we suspect that it could be?
Still reviewing.
Still reviewing, still under investigation. To say the neighbors have any surveillance cameras, but I probably imagine we went to every neighbor about 12 times already. But you have anything, let us know.
Do you expect to release the name of the victim anytime soon?
No, I mean, the family can, but we won't.
Was the victim Hispanic as well?
We're not going to release that information.
How cooperative is the father of roommates?
So as of right now, they're being very cooperative. Everybody that we spoke to has sat down and spoke with us and helped out.
Any other questions?
His gang affiliation, does that date back to his time in
Indiana, yeah. He wasn't in Florida that long.
When he was on parole in Indiana, how does that work with working with those entities at this point?
With Indiana, so our Department of Corrections will work with their Department of Corrections. Yep.
So, obviously, this is a second story that we've had around delivery drivers. drivers. Do you have any tips for people who maybe are delivery drivers to keep them safe?
So tips for delivery drivers, I would say, it's like anybody who's out there. If you're knocking on a stranger's door, and I get this is the same thing also where people, they go online and they buy stuff from each other and they meet up. For people who are buying stuff and meeting up at places, I'd say always meet well-lit place, a gas station, in the middle of the gas station, meet there because there's cameras, there's people out there. If you're a delivery driver, if you don't feel comfortable, don't go. We have body-worn cameras in law enforcement to protect ourselves and protect other people. If that's something you want to do is videotape everything going on. If you want to be on the phone with somebody while you're going up to that house, do that. There's nothing that stops you. You're in a public place. You can do what you want. But as I say, and that's the thing, it's not about the victims here. It's not blaming them, and I don't think you are, and I don't think anybody is. But the issue is we just got horrible people out there. And so always remember that. There's just horrible people in this world. There's just people that are just hell-bent to do evil. And so... No, he's not. So, that being said, well, appreciate it. By those individuals can come forward. If the family knows them, please come forward. We want to get some more information because we have to bring justice for this family. Thank you all very much.
Thank you. Thank you.
All right, so that was the news conference. That kind of introduces the story of Randall Cook and Oscar Solis, right? So let's go to some continuing. Now we're going to get to know Randall Cook just a little bit. So we're just going to kind of go through a couple news clips now, and then there is.
Now this morning we continue to.
All right, hold on. So now this is going to tell us a little bit about Randall Cook.
Follow the latest developments out of Pasco County. Last Wednesday, the sheriff's office says a food delivery driver was murdered in a crime the Pasco County Sheriff's Office calls evil and demonic. 30-year-old Oscar Solis is now behind bars, but the sheriff says he's not talking.
And the family of Randall Cook tells us he was a hardworking, loving husband and father. His family sat down to talk about his life and legacy. Let's go to our Heather Lee. She's in studio with us. She's been studying this story here for us. And Heather, you have more details.
Yeah, good morning, James. Good morning, Dia. This is such a tragedy. His family tells us he was just trying to make a living. Instead, his life was cut short, and detectives believe it was random.
Melanie DeZoba talking about her stepdad.
He was perfect in every way. Perfect dad. Always there, just no matter what.
His life taken suddenly at the hands of a stranger.
I still have a voicemail on my phone from last Monday of just his voice and him telling me how much he loves me and how much he's there for me.
Randall Cook's murder is being described by detectives as demonic.
Cook was an Uber Eats food delivery driver. He was making his last delivery around 7 p.m. last Wednesday when the Pasco County Sheriff's Office says 30-year-old Oscar Solis pulled him into the home and murdered him.
There's no way someone in their right mind did something like this. I mean, doesn't make sense. The minor details aren't adding up.
Cook came into her life in 2012 when he met her mom. The two got married in 2020.
Just conjoined at the hip, soulmates to the very end.
By trade, Cook was a talented graphic designer, according to DeZoba. He was doing Uber Eats recently to make some extra money. A humble man, she says, never said anything bad about anyone.
He was the most perfect man, and I can hope that there's a guy out there even close to him for me, you know?
Now, the DeZoba family set up this GoFundMe for funeral expenses. You can see it here. We actually have a link to this on our website if you would like to help out. Our website's going to be abcactionnews.com. Again, just find the article on our website, and there is.
All right, so that gives you a little glimpse into Randall Cook's life, if you will. Graphic designer. Seems like a really cool guy, right? And Oscar Solis. That's the way they pronounced it. Solis. I was saying Solis. Oscar Solis. All right, so here's a couple more news conferences before we get into his motions hearing. It's not from
turning
today,
now to the murder of a food
because they're not showing it, but we do have one we can show you. All right, so here's some more news just to kind of give you a full understanding of what's going on.
Delivery driver in Pasco County.
And the man accused of killing the driver is now behind bars.
Yeah, the sheriff says the suspect, identified as Oscar Solis, isn't talking, and they don't have a motive, but they have evidence, including the victim's body, which they say was found in trash bags at the house.
ABC Action News reporter J.J. Burton has been on this story all day long, and he has the very latest on the murder, plus the fear from other delivery drivers.
Hardworking and loving. That's how Randall Cook's wife and stepdaughter describe him. Sadly, he was murdered while working.
These are just a gruesome case, and this is horrible.
Sheriff Chris Nocco says Cook came to 3438 Moog Road to make his last Uber delivery just before 7 p.m. on the 19th.
You can actually see the victim walking up to the house to deliver food, but the video cuts off at that point.
Detectives say that order was for 30-year-old Oscar Solis. After the camera cut off, they believe Solis killed Cook, then dismembered his body.
He's a very violent individual.
Cook's murder has other delivery drivers, like Kalina Rios, terrified.
I'm scared as hell, excuse my language, because I'm out here at night and I did many deliveries in the same area.
Rios says she's going to make some changes, and she has some tips for other drivers.
I keep my car running. That's why a lot of people turn their cars off. I keep it running at all times because you never know if you're in a bad situation. You want to be able to get in that car and leave.
The most frightening part for Rios and others, detectives say this was random. And Cook and Solis don't know each other, and they don't have a motive because Solis isn't talking.
You can never answer the why, and that's what I feel horrible for the family for.
Nocco says there's surveillance video showing another man helping Solis carry trash bags with Cook's body parts in them out of the house. But they say that man didn't know what was in them. Solis also has a roommate, but he wasn't home at the time, and they say he didn't know what happened. Solis's father is the one who ordered the food and is renting this house with the roommate so Solis could stay here. Nocco says the father also had no idea what happened.
You actually see on the following day, on the 20th, the suspect, Oscar Solis, was carrying trash bags with another individual, and you can see them carrying these trash bags around the side of the house.
Solis moved here from Indiana back in January. He has a long criminal history and possible gang ties in Indiana, according to the sheriff. Investigators are also looking for the two people you see in these pictures. They're not sure who they are, but they were in this house, according to investigators, an hour before Cook was murdered.
If anybody has any information, please come forward. As I said, you're not in trouble. We just need to keep building this case, because we in Florida will bring justice for this family.
J.J. Burton, ABC, Action News.
All right, so that's two things I learned. Dad ordered the food, and then they just showed the two kids that the law enforcement wants to come forward. You're not in trouble. They want you to come forward. So Dad ordered the food. Dad also owned the property. So Oscar's father owned the property, moved out so that Oscar could move in when Oscar moved from Indiana down here to Florida. Dad owned the property, moved out, let Oscar move in, and ordered the food. And then his son does this. I don't get it. I don't get it. All right, I got two more news clips. Let's see what else we can glean from.
For days, Pasco County.
Let's see what else we can glean from the news.
For days, Pasco County crime scene technicians and detectives went through this home on Moog Road. Sheriff Chris Nocco says he will not go into specifics out of respect for the victim and his family, but he says his team saw gruesome things in the home.
It was a horrible scene for them out there for several days. It was tough.
Sheriff Nocco says the victim texted his wife on April 19th saying he was about to make his last delivery for the day for Uber Eats. The sheriff says security video shows the victim arriving at the home.
We watched the video. He's a guy just like everybody else, just trying to make a living for his family.
Later that evening, the victim's wife reported him missing. Detectives then obtained his last known GPS location from Uber Eats and tracked him to this home. Later, detectives found trash bags outside of the home.
Unfortunately, what we found inside of some of those trash bags was human remains.
Detectives then arrested Oscar Adrian Solis, charging him today with first-degree murder. The sheriff says Solis has a long and violent criminal history in Indiana.
Burglary, battery, battery on detention staff. He supposedly stabbed somebody several times while he was in prison in Indiana. So you're talking about a very violent individual that Indiana released and sent down to Florida.
Kalina Rios is an Uber Eats driver who also makes deliveries in this neighborhood and says she is now terrified to work because of what happened here.
I have to think of other safety plans now because I do the same thing this Uber driver do. Dropping off a simple order, it could have been any of us.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news.
All right. So we have one more news clip, and then we're going to get into his motions hearing. Not the one from today, because unfortunately they're not airing it, which really stinks. But we do have a motions hearing.
Details tonight about the murder of this.
So this is one more news clip, and then we'll go to the motions hearing.
Uber Eats driver Randall Cook never made it home to his family after his last delivery in Pasco County earlier this month. And now we are learning the evidence stacked up against his accused killer, Oscar Solis. Fox 13's Kylie Jones is in our newsroom tonight with a look at what deputies found. And Kylie, it is disturbing.
Ellie, it is. Reading the criminal affidavit, it does create a chilling scene inside that home on Moog Road. Blood in several rooms of the home. The victim, Randall Cook's wedding ring, wallet, and car key fob inside. And then the suspect, Oscar Solis, his time card was left behind in Cook's car. As this mystery unfolds, investigators are filling in the blanks, detailing days' worth of evidence that led them to arrest and charge Oscar Solis with murder.
This was absolutely a horrific crime of passion.
He's accused of brutally killing Uber Eats delivery driver Randall Cook, who was reported missing by his family last week.
You always say the word evil, but this is demonic. This individual what he did was demonic.
Pasco County Sheriff Chris Nocco says Randall Cook was making his last delivery of the night. Home security footage shows him making a delivery to the home Solis rented.
When you watch that video, he's literally standing there just waiting, and he probably was thinking to himself, am I at the right house? Because nobody was answering. But then the camera goes off.
It's unclear exactly what unfolded next, but investigators say that was the last time Randall was seen alive.
This person just yanked him in and killed him.
According to an affidavit filed this week, shortly after that, Randall's wife got worried. Her messages to him didn't deliver. Investigators tried to ping his phone, but it was off. Then detectives looked at security footage the next day from the back of the house.
Oscar Solis was carrying trash bags with another individual, and you can see them carrying these trash bags around the side of the house.
Investigators believe the two men were Solis and a driver who Solis's father hired for his son. The driver mentioned an odor in the home when Solis asked him for help taking out the trash. Ultimately, deputies found Cook's remains inside.
This is just a random person. It could have been anybody.
Detectives talked to Solis's roommate, who lived there with his wife and child. The roommate heard a loud noise coming from Solis's bedroom the night Cook was delivering to the home. Because they felt uncomfortable, they left for a hotel the next day. And of course, one of the biggest questions that is still unanswered is what motivated Solis to allegedly do this. That's a question the sheriff just doesn't know right now, saying he kept asking himself what could be the connection between Solis and Cook. Today, Solis entered a not guilty plea to the crime in court.
It is just so disturbing, Kylie, and to think it was just completely random. Hopefully we can learn more soon. Kylie, thanks.
Wow, Billy. So you are a driver. Yeah, I would. You're rethinking that career choice. Crazy. All right. So we found out a lot. We found out that Randall Cook shows up. He's just kind of hanging out. Last delivery of the night. All of a sudden the camera goes off. He doesn't know that. Probably doesn't even realize there's a camera. Camera goes off, and then somehow he's pulled inside, or he makes it inside. So the house was owned by Solis's father. Solis's father moves out. His son comes down from Indiana. Then there's another roommate that has a wife and a child. They hear, or at least the one roommate hears noises coming from Solis's bedroom. Surprised he didn't hear like screaming. So he must have had his mouth covered, or else Randall Cook would be, absolutely screaming and yelling and all kinds of stuff. I'm sure he's fighting back. Doesn't seem like he's that small of a guy. He's certainly not as large as Solis is. We'll play the motions hearing so you guys can see how big Solis is. So now this one is about an hour and a half, this motions hearing. So then Solis asks the roommate to help take the trash out, or a friend comes over to help take the trash out, and it's Randall Cook. Unbelievable. All right. So this is a motions hearing.
Trial. And that's all right.
All right. I do like this judge. You guys will like this judge. He's pretty cool. And you're gonna get an eyeful at how big this guy is. If you don't know already, he's a big dude.
So, for the record, we're here on 23 CF1637 for digital court reporting. We have a live court reporter here. We're getting Mr. Solis from back. All we do is just put the preliminary, things on the record. We have Mr. Sarabia and Mr. Diskey here from the state. We have Mr. Crawford, Watts, Treatise here for the defendant. We're not doing anything substantive until we get Mr. Solis out. And then once he's here, I need to put a couple things on the record before we hear from everybody.
That's right.
So if you want to have a seat, you can.
Okay.
All right. If you want to stay there, obviously more than welcome to.
I wanted to ask the court a quick question before he gets in.
Sure.
Well, we're out here.
All right, Mr. Solis is coming out. Hold on one second. All right, we'll just wait for him to get situated. All right, so Mr. Solis is here. Mr. Crawford, go ahead with your question.
Judge, very briefly, I realize the court is triple booked. I respect the court's time. However, if we get done with the motions in a reasonable time, will we get a little clarification on Your Honor's jury selection process that was in the order?
Yes.
Thank you, Your Honor.
All right. So, for backstory, we're here. This hearing today was set by order that I entered on November 8th, which I believe was after our last hearing on other motions. And what I did was to make sure that we were staying current with everything, to make sure that nothing got lost, and to make sure that we were ensuring that Mr. Solis had all of the issues that he wanted to have heard litigated prior to his trial. I basically been leapfrogging us and set a deadline for notices of hearing, and said that everything prior to that date that was properly noticed, we would address today. And anything that was filed prior to that date that was not noticed was deemed as waived without prejudice, so that our record stayed clean and clear, and everybody knew that we were addressing everything that needed to be addressed. Trial is not set until August 22nd, so we still have, August 25th. So we still have plenty of time. We already have an Arthur hearing set regarding Mr. Solis' pretrial detention. I didn't write down the date, but that's coming up, I think, next month.
3/14.
March 14th. All right, so a month and a half. Now, we have motions from both sides that were noticed for today. Based upon the motions that the defense has filed, I think it makes sense to start with the state's motion.
It does.
Okay. So, Mr. Sarabia, on September 19th, the state filed a motion to amend the notice of intent to seek death, and you wanted to add 2 aggravators. Is there anything that you did not put in your motion that needs to be addressed or that you want to be heard on?
I do not believe so, Judge. Just to stress that while we always suspected and thought that there were some reasonable inferences from the evidence that these aggravators may have existed, we did not have the evidence to establish them that we felt we would need in order to establish them at the hearing. Since then, we did the depositions, and that one of the witnesses' testimonies was more forthcoming And now that evidence is there to establish these two additional aggravators. And so given that, we timely did a motion to amend and add the additional aggravators. And I note that the rule says that upon good cause, the court can allow us to do so. I believe that that's good cause because these were not facts that or testimony that was available to us before, because we're talking about young witnesses who have disclosed more complete information over time.
Mr. Crawford, anything that you want to be heard on?
Your Honor, Mr. Petridis.
All right, Mr. Petridis, anything that you want to be heard on?
Just briefly, Your Honor, we would object and argue this is not good cause. The state has had access to the witness in question for some time. This isn't a situation where he or she would have been on the run and they finally got to them and got the information. He's given multiple different stories, and we would argue that the fact that he's changed his story to now the current story, which they believe gives them two new aggravators, is not, in fact, good cause to allow this.
All right, so let's start here. The state's motion was filed September 19th of 2024. Trial in this case is not until August of 2025, so there's still plenty of time before trial. And the trial that we have set is technically our second trial date in the case, but based upon an agreement of the parties, so that we litigate issues, we moved the trial. We all agreed to move it early. We didn't wait till the last minute. But this case is set for trial because I have been keeping things moving to make sure that it doesn't languish, which is why I set deadlines and why we're having these hearings. 782.04 paragraph 1B says that the state has to file their notice of intent and their aggravators within 45 days of the arraignment. There's been no objection to the state's initial notice of intent. Aside from the motions regarding declaring it unconstitutional, nobody's saying that the state is not in compliance with the statute initially. The same section, as Mr. Schrader said, allows the state to amend the notice of intent upon showing good cause. What the state's alleging, which I have no reason not to believe, is that the information that came up itself was not really gleaned or learned until the discovery process, and it was a defense deposition that I guess developed this additional information. Now, because aggravators require evidence, aggravators require findings by a jury, an aggravator, or the fact that the state is relying upon an aggravator does not in and of itself prejudice a defendant any more than the fact that he's on trial for first-degree murder and the state is seeking the imposition of death penalty. It simply gives them another avenue or another theory under which they could proceed. So I don't think that there's any prejudice, not that that's even the standard here, but I don't think in any way there's any prejudice to Mr. Solis. And because of the time that we have between now and trial, I don't think that there's any prejudice to him or any prejudice is cured by the time, and we can always grant more time to prepare for trial if we need to. I'm not making my finding based upon a prejudice standard, however. I'm making my finding based upon, or my ruling based upon a finding that the state has set forth what I consider to be good cause, that they learned this additional information during discovery, and because the statute allows me to grant their request upon showing a good cause, I will grant the state's request. I will allow them to file an amended notice of intent to seek death with all of the statutory aggravators upon which they want to rely, meaning the ones that they have already filed and the two new ones, but obviously they are more than welcome to drop any of those off if they want to, but whatever amended notice that you file, that's the ones that you're going to proceed to trial on.
Judge, it would be my intention to file an amended notice with all of them listed in the next couple days.
I was going to give you, I was going to say, could be 2 weeks from Friday. That should be enough time. Is that enough time for you?
Yes, thank you.
All right, so I'll say by the end of business on February 14th to file. Okay, so that takes care of the state's properly noticed motion. Although I say properly noticed, I'm going to put that in quotes because this applies equally to both parties, so I don't want anybody to think I'm picking on one side or the other. My order regarding the notice specifically asked you all to please include the date of the item that you're noticing, to make sure we're referring to the state one, or the correct one, because the defense filed 1, 2, 3, 4, 5, 6, 7, 8 motions that they noticed for hearing today, and I had to sort through to figure out which is which.
Understood.
That's okay. It's not faulting anybody. That's what I did. So I figured, Mr. Crawford, we'll just take them one at a time in the order that you noticed them, which is almost the order that they appear in the docket, just to make sure that we don't miss anything. Does that sound like a plan?
It does, Your Honor.
All right, so the first one that you noticed was a motion to compel the victim impact witnesses and written statements. It's docketed on September 20th. It's the first item docketed that day. And if I understand everything correctly, you want the state to both disclose any victim impact witnesses that they intend to rely upon, have those statements reduced to writing, and then have a hearing sometime before the trial to determine the admissibility. Is that right?
Correct.
Anything that you want to say or add that's not in the written motion?
Just briefly, Your Honor.
Mr. Petria, sure.
Just like we said in there, we believe that that statute about victim impact can be difficult to interpret, and what we're trying to avoid is objections during the trial itself of victim impact statements. And so we might not need a hearing in front of you, depending on what's in the statements, but we'd like the statements to be done so that we can see who's on the victim impact witnesses, what they're going to say in general, and then, if need be, have the hearing prior to the trial and outside the presence of a jury. So we don't have to, as you're well aware, and the state is, this can be very emotional statements, and we don't want to have to object if it's not absolutely necessary. So that's what we're trying to avoid here.
Mr. Straight, anything you want to be heard on, you or Mr. Diskey want to be heard on this one?
Judge, I would just note, one, Ms. Cook, who's president of the court and has been present at all hearings, is definitely going to give impact evidence. We have been in discussions with other witnesses, and the defense has been aware of this, about whether they will want to or not. And I don't believe that they will at this point. However, we're giving them the opportunity that as time develops and as perhaps bigger the case, they may want to. And there's one additional witness that I need to make contact with. But it is the next of kin's right, the victim, the people who are affected by this is right to do so. I think it would be burdensome on them to do that well in advance of trial. They're asking for it before jury selection. We don't even know yet if the defendant will be found guilty in theory before then, and to force them to reduce to writing something that emotional without, and perhaps never even get to the point where they're going to use it, I think would be unduly burdensome. All that said, discussions with Mrs. Cook, I think we will get to a point where she will probably reduce what she's going to say to writing so that we can avoid any surprises during the sentencing portion of the trial itself. But I would note that this is not an issue that I expect would affect at all the guilt phase of the trial.
All right. On the one hand, I don't think it's overly burdensome, an overly burdensome ask to know who the victim impact witnesses will be. The flip side of that is I can't stop somebody if they want to, if they have a statutory right to appear and be heard. I can't stop them from coming to speak. So here's what I'm going to say. This is almost a be careful what you wish for. I mean, you're entitled to engage in discovery. I will grant this request in part. Now, I'm not, because trial's still coming up, and everybody, I think, has a lot more things you probably need to worry about. So I'm not going to make this an immediate thing. But I am going to ask the state to discover a list of all potential victim impact witnesses. Basically, anybody that you all believe who's going to, or would want to, or might want to testify and give an impact statement, who has a statutory right to. I mean, we're not calling, the dog walker down the street just because if they don't have a right to be heard. I'm going to set a deadline, but I'm not going to do it up front that way. Because here's the other thing. I mean, these are people that you're asking me to put on the spot months in advance to ask whether or not should there be a conviction and we get to a penalty phase if they're going to want to speak. I mean, we're asking them to commit a lot too. So I'm going to set the deadline because you all obviously are going to need to prepare your guilt phase trial strategy as well as any penalty phase trial strategy. I'm going to say that list needs to be by the end of business. I'll tell you what, I'm going to do July 7th. That gets you after the holiday weekend in case anybody's So I just want you to discover the list of everybody. That way they can talk amongst themselves and decide who they think is going to be. Now here's the issue, I don't know that statutorily I can exclude anybody, so I'm basically going to ask the state to think of everybody that might possibly testify. You obviously, the defense is allowed to engage in discovery, you're allowed to talk to them. I don't know if the state is going to have their primary one reduce their statement to writing. I'm okay, I'm not going to order them to have all of these people reduce their statements to writing. While I appreciate that we're trying to avoid objections, I'm now limiting them as to what they can say also. I'm now basically asking them, rather than coming and speaking on their own and having it be fluid and having it be spontaneous, for lack of a better word, I'm asking them to basically prepare written statements that they're now going to read into the record. And I don't want to limit them to that if that's not what they want to do. I will say that if any of them do prepare any written statements, to discover that to the defense, I'm going to ask the state that if they do, to provide it to you all, and then I'm going to ask you to discover it to the defense upon receipt. And I will allow, rather than us having a hearing, I will allow the defense to file a motion in limine regarding the victim impact the contents of the victim impact statements. So if there's something that you all believe that you anticipate somebody testifying or saying, or if you do get a written statement and you see something that you believe is objectionable, I'll allow you to file a motion in limine. We can address that outside the hearing of the jury. But I don't think we need to do that before we ever even pick a jury, because the jury's never going to hear that unless we get to a penalty phase.
But one clarification I'd ask for, Judge, if we receive it and it's a draft, because sometimes we will work with the next of kin to discuss, like, hey, we don't think this should be in there, that's really not what the statement is for. We will work with them in advance to try and eliminate things that might be a problem. That is not what the court is talking about. Or the court is talking about what could be the final product.
Right, no, I'm simply saying if they send you something saying this is what I want to say, or you said that the next of kin who's here today had indicated that you were going to work with them and that she may reduce her statement to writing. If you get that, please provide that to the defense.
Okay.
I am not holding anybody to their written statement. I'm not saying that if they write it down, that's the only thing that they get to say. But if those are going to be the contents or the types of things about which they are going to speak, the defense should know in case there is something in there that is clearly not relevant or would be objectionable. That way they can raise it and we can address it outside of the hearing of the jury. But I don't think that anybody wants to interrupt a victim impact statement. And I know that the defense doesn't want to do that either. But the other thing that I don't want to risk is, hypothetically, they do say something that would be objectionable or could be objectionable, and we make it all that way, and now we're having to deal with something that we could have avoided in advance. That's all. So I will say that by end of business July 7th, the state needs to get a list of any potential victim impact witness. Anybody who decides, who thinks that they might want to provide a victim impact statement needs to be on your list. You need to send that to them. Anybody who reduces their statement to writing or gives you a draft of what they want to talk about, I'm simply going to ask you to provide that to the defense. Obviously, the defense is allowed to investigate victim impact statements in discovery because the penalty phase is a whole separate proceeding. And I'll allow or entertain any motions in limine regarding the contents of the impact statements, but that does not need to be addressed necessarily before we pick or swear a jury.
So then, Judge, you do want us to provide any draft that we get?
If you do get something, yes. And if you want to note it as a draft, that's fine. And if you want to let them know that you've already talked to the person and said they're not talking about these things, that's okay. You all have been doing a lot of work behind the scenes without me. That's what lawyers do. If it's something that you think I need to know or address, somebody bring it to my attention. If you represent Mr. Crawford or Mr. Treatise or Mr. Watts, that you know that the person said this, you're not letting them talk about that, and it's not an issue, then they just won't bring it up to me. Or if you all want me to remind the person not to say something, I can do that too. I'm trying not to make, I understand the ask, I don't think it's unreasonable, an unreasonable ask. I'm trying not to put too much of an onus on these people who have a right to come and speak. So I'm not trying to tie anybody's hands. All right, anything else on the first motion?
No, not from the defense.
Second motion that I have is a motion in limine regarding photographs. It's docketed September 20th, 2024. It is the second item docketed on that day. So, all right, Mr. Crawford, here's my concern. It's a motion to preclude pictures that are either too graphic or are cumulative. I'm sure, Mr. Straby, how many pictures do you think there are in this case?
I think we sent them, per your orders, a list which has the exact number.
Probably at least a couple thousand.
Yeah, I think it's 4,600.
That's fine. We've got over 4,000 photos. Here's my concern with that, with addressing this one right now, Mr. Crawford. I'll give you a chance to be heard. If there were specific ones that you wanted to address, we absolutely could. But my concern is the fact that it's kind of vague right now. So go ahead.
So, Your Honor, to kind of, not to interrupt, but I did speak with the state earlier today regarding this motion. Here's what we would propose, which might answer the court's questions. Clearly, based on the nature of the crime and the crimes that are in the indictment, there's going to be some very graphic photographs that the state is going to present, both through the medical examiner, the blood spatter expert, potentially the lead detective. We've got an Arthur hearing that's set, obviously, for March. So it's my understanding that the state is going through a lot of those photographs right now. What I would suggest is that both the state and the defense meet once they have their final list of photographs. Then maybe we can have a hearing about 2 weeks before trial where we can put our specific objections to those photographs. The court can look at those photographs, make specific rulings for the record. That way everything's properly preserved.
Mr. Schrager, before I hear from you, I'm just going to let you know this was my thoughts on the issue were along those lines, but obviously I'm not making a ruling. My thought was that I'll have you all exchange witness and exhibit lists prior to trial. I'll have the state include in that the specific numbers of exhibit or photographs that it's their intent to introduce. And then I'll let you file an objection listing out the specific ones and why. And obviously if the state agrees and decides not to, it's moot. And if not, then I can make a pre-trial evidentiary ruling, for lack of a better word, on whether it's, there's limited reasons why I can exclude photographs. Either it's cumulative, it's not relevant, or if it's unnecessarily graphic. Like everybody just said, clearly there's going to be some graphic photos that are inherent just in the nature of the allegations here. But Mr. Schraby, your thoughts?
Yeah, and Judge, my immediate thoughts are the motion's too broad. I can't respond to it. I don't know what photographs he's talking about, so you should deny it. That said, absent a judicial ruling, Mr. Crawford is right. We conversed. I have every intention of trying to limit nobody wants to see more photographs in this case than they have to, myself included. And we're going to pick photographs that we feel are relevant, that the relevance outweighs any prejudice, and that is important to make sure the jury understands why our case is proven. And so we're going to be coming up with those in advance. What I've done on some cases similar to this, where there are those issues, specifically medical examiner photos, we may go over that with you in advance, and I don't have a problem doing that. The March hearing, we're probably going to admit a number of photos, which may give the court some idea of what we're intending to present. All that said, depending on how the defense responds, depending on what issues come up in trial, may make other photos more relevant, may make certain photos that we did not initially intend to admit now important, and we don't know. But I would ask the court to not give us a blanket ruling of any case that's going to say no more photographs. And I think it's incumbent on the court to take the photographs as they come, keeping in mind that all of us are going to be trying to do the same thing, which is give Mr. Solis a fair trial that there's no problem with in the future, and that the evidence is fair and appropriate under the code of evidence. So, again, all that said, Mr. Diskey and I intend to be very prepared so that Mr. Crawford knows exactly what we're going to do. Out of those 4,000 something photographs, we're going to pick out the ones that we feel like we need to give the jury an idea of the location, the situation, the events that transpired, and the injuries and so forth that occurred that prove the crimes, not just count 1, but also count 2. So we will be trying to be prudent with the ones that we pick, and pick only the ones that we need and a minimal amount of the ones that are out there. And again, it's my intention to make Mr. Crawford aware of all of those that we intend in advance. But I don't want to be held to that because I don't know what's going to happen as this plays out.
All right. To avoid issues, I'm not worried about anything that comes up at the Arthur hearing. The Arthur hearing is just me. I mean, there's fewer objections or concern about prejudice and a jury. The exclusion of photographs in a case like this usually has to do with the jury. We don't want to inflame them. We don't want to make them unnecessarily sick. We don't want to add cumulative evidence, etc., etc. The Arthur hearing, you present whatever you present. If there's a legal objection, obviously I can consider it, but there's no jury. I understand the concern. Let me back up. As I said, I think the motion is a little bit vague because you're not specifically objecting to any photographs in particular. You're just saying you basically want to hold the state's feet to the state of the law, which is my allegation. You've made a preemptive objection. Now, having said that, again, to try to make sure that we have an efficient trial and a clean trial, for lack of a better word, I don't think it's an unreasonable ask. Mr. Sarabia's trial is set to begin August 25th, which is a Monday. I know that generally speaking, you don't finalize things until the last minute. I mean, that's every lawyer. But big picture, probably by a couple of weeks before the trial, you should have an idea of what it is you're intending to introduce.
That is the goal. It's hopefully going to be a lot earlier because again, we're hoping to use the bond motion as a dry run for photographs and things like that.
Okay. So here's what I'm going to say. I'm going to ask the state, or direct the state, to provide an anticipated exhibit list. Anticipated, I'm emphasizing that. That means I'm not holding you to it. But based upon your trial prep, what you reasonably believe you intend to rely upon or seek to introduce at trial, including photographs with the numbers. I'm going to ask you to have that by the end of business, August 15th. That way, Mr. Crawford still has a couple of weeks to review it. If there's something that he believes is either cumulative or objectionable, we can address it sometime before we get to that point with the jury.
So the one thing about an exhibit list, because there are multimedia exhibits, surveillance videos, photographs, depending on some of the things that I've already discussed with Mr. Crawford, stipulations to certain surveillance videos, we could do one exhibit per video, we could do one exhibit with all the videos.
A list of the items that you intend to introduce, meaning if it's just a list, meaning if it's a redacted video, however it's identified in the discovery. Okay. If it's a photograph, simply the photograph numbers. I'm assuming that they all have file numbers or something. Some way that without them having to hunt and peck, the defense can reasonably identify what it is that you're referring to. That's all. It doesn't need to be a spreadsheet. I'm not asking you to give something to the clerk so that they'll know as you're moving things into evidence. I'm simply meaning so that their biggest objection here is photographs, so that they can take a look at it, look at the photographs to see if there's something specific that they're objecting to, That way they can lodge their specific objection and we can narrow it and address it. We can do it one of the days during jury selection or before or after, outside of the presence of the jury, but that way both sides will have an answer before we ever get to that witness. Again, there's really only a limited number of reasons why they could object to it, and Mr. Crawford might look at the photos that you're seeking to introduce and not have any objection to them, and then it's not an issue. But at least that way, to his point, we don't have to stop with every photograph and take the jury out.
And then the last thing, Judge, is due to my personal availability, could we do the 19th? Because the 15th would be
That's fine.
a problem for me.
That's fine. I'll say end of business on the 19th. That's reasonable. It's still a week and a half before trial, which is still plenty of time for the defense to look at them and see if they have any specific objections. All right, anything else on that one?
There you go.
All right, the next one is the motion to compel the penalty phase witness list. It's docketed September 20th. It's the third thing docketed on that day. And my understanding is you just want a separate list of who they anticipate calling during the penalty phase?
That's correct, Your Honor. We provided a list. We would just like a list so we can fully prepare.
Mr. Sharabian, does the state have a...
Judge, the witnesses that we intend to call for the penalty phase are all included in the witness list at this time. And I've been very forthcoming. And as Your Honor knows, this will depend if the court does exclude some portion of testimony during the guilt phase. I may need to call that witness back for the penalty phase, whereas the court doesn't, then I don't. So it depends a little bit on what's presented in the guilt phase, because that will limit the number of witnesses I have to produce in the penalty phase. That said, there are some witnesses that only pertain to the penalty phase, and I've already made defense aware, and that's the witnesses regarding Mr. Solis' prior stabbing conviction from Indiana, where he stabbed somebody in much the same manner as he did in this case. We have elected thus far not to pursue that as Williams' rule or to pursue it in the guilt phase. Those witnesses pertain to the penalty phase. Other than that, I'm not aware of any witnesses that uniquely pertain to the penalty phase that don't also pertain to the guilt phase, and we might, again, depending on what the presentation ends up being in the guilt phase or what the court's rulings are on certain evidence, and just to give you an example, the court might say the photographs from the medical examiner are not relevant for the guilt phase. However, then when we got to prove certain things in the penalty phase, they might become relevant, and now we got to call that witness again. And yeah, it's just an example.
Let me ask you this.
I'm not trying to hype the ball on this. I've been very, very open. Almost all the things, all the aggravators, and now the new ones that the court has granted motion for, they're all inherent in what the guilt-based presentation would be, other than the prior conviction. And those are the witnesses, I think there's 5 or 6 of them from Indiana, the corrections officers and the victim. Again, we've had these conversations, so I don't think, I'm not aware of any rule that required me to do this.
Let me ask you this, when you provided your witness list, did you differentiate between A, B, and C witnesses?
I don't believe so. They're all category A because all the witnesses I added have some potential to be called, and depending on what they do. There's a lot of them that might be negative evidence that we probably won't need, depending on what the defense does. But they all have information in some sense, and this is not, there's not a big mystery here, I guess is the bottom line.
All right. Anything else that the defense wants to be heard on?
Your Honor, one of the things we've been very, very clear on, and we've specifically delineated which are penalty phase witnesses that we intend on calling. The concern that I have here on compelling, especially the penalty phase witness list, is if the state intends to call any experts. We've already listed all our experts, provided all the reports. What I don't want to do is be in a situation where we're a week or 2 before trial and then we get an expert listed right before the trial. So that's the concern that I have about the penalty phase witness list. Also, if the state is intending to call some people who reside in Indiana, especially the alleged victim of the previous stabbing. He's going to have to be transported down here from Indiana and housed at the Pasco County Jail. I just asked that if that is going to be done, that it be done in a reasonable amount of time before trial so we can properly take that witness's deposition, which we're entitled to do under the statutes.
Well, under the rules you are, but under the rules, if you want to take their depo, you actually have to go where they are. So you have the right to travel. I mean, I understand your court appointed, you have to get approval. It's a death penalty case. I can't imagine them not approving it. But technically, you need to go and pose them in the county where they are, or the state where they are.
Still, if they're going to call a witness, he has to be live and be transported down here from Indiana. He can't be done remotely, especially in the penalty phase of a death penalty case.
Right. I got that. I mean, here's my concern. Mr. Sir, again, I don't think it's an unreasonable ask. Now, the experts will talk about in just a second, because did I not set deadlines?
You did. If I could respond to that. They provided us some experts, and we do intend to do depositions, but whether we may decide to get an expert, they won't be able to deal with Mr. Solis until we're past the guilt phase, to begin to interview him and things of that nature, if we do it. Thus far, we haven't listed anybody. So right now, there is no expert for the penalty phase. If that happens, then we will let them know. And if there's going to be an expert that we're going to use for the penalty phase, I will let them know that it's for the penalty phase. Right now, we have Anna Cox listed as an expert. We intend to call her in the guilt phase, but we may also call her in the penalty phase if something doesn't come out in the guilt phase that we feel we need for the penalty phase. So she doesn't pertain to one or the other. If this is just about mental health doctors, head doctors, if we list them, we will let them know. We will delineate that they are exclusively for the penalty phase.
Yeah, I've got a few concerns. You can have a seat. Number one, I don't think it's an unreasonable ask, but like Mr. Serratia said, if I grant a contemporaneous objection, or if there's a motion in limine, or there's something that's not relevant, and the jury doesn't hear it in the guilt phase, but it then becomes relevant in the penalty phase, I don't want to stop them or preclude them from doing that. And we're not going to have any way of knowing what that's going to be unless I either A, start making a whole bunch of pretrial evidentiary rulings, or B, we get into the trial. Two, regarding the experts, I'm really not as concerned because I thought that I put deadlines on that. So that should fix that. Three, regarding the transport of the witness from Indiana, again, not stopping you from taking the deposition. I understand it would be easier to do it here, but we don't transport people simply so we can depose them. If he's here and you all can, absolutely. But if you want to, there's still plenty of time for it to warm up in Indiana if you all need to make the trip. And I say that jokingly, but I mean to ask for the money and to be able to travel. The last thing is, and this is, I like to plan for all possibilities here. If for some reason there is a delay between the guilt and the penalty phase, like what Mr. Serratia said, there's an expert that's all of a sudden going to talk to the defendant, he doesn't get to do that until after there's a conviction. Or if for some reason this jury is not the same jury that hears the penalty phase, for whatever reason. I don't want to limit the state because we don't know what evidence the jury is going to hear. So there's no requirement to specifically delineate a penalty phase witness. I mean, it's not necessarily a bad idea that they do that, but they provided a witness list. The rules of discovery still apply. Because what Mr. Serratia said, that some of this may depend upon the evidence that's actually presented to the jury and what isn't, and what becomes relevant or becomes necessary for them to present the penalty phase, I don't want to say that they can't call somebody. If I did anything, what I would be inclined to do is ask the state to provide you with a preliminary anticipatory witness list. But again, that would be kind of like the photographs. I'm not holding them to it, just as their trial strategy is at whatever time 2 weeks before the trial, with the understanding that that can completely change given whatever occurs at trial.
And that's all we're asking for.
All right, I don't think that in and of itself is an unreasonable ask. So I'll do the same deadline, not end of business, what did I say, August 19th. An anticipatory witness list for the penalty phase. And again, if you believe, Mr. Sraby, that you're going to be recalling or calling the same ones, that's fine, you're allowed to include it. What I don't want is a list of 200 Category A witnesses, and I'm not going to hold you to it. I'm not saying that you can't call anybody that's not on the list, but just those that you reasonably anticipate calling. That way, if there's something there that they want to address before we get to that point, understanding that until there's a conviction, talking about a penalty phase is kind of, it's not entirely right. But obviously, we want to avoid delaying the proceedings as much as we can. All right, so anything else on that motion?
There you go.
All right, motion number 4, what I'm calling it. September 20th, it's the motion to disclose the grand jury testimony. It's the 4th thing that's docketed that day. Now, upon reading this, my understanding is that you're asking me to disclose grand jury testimony because you believe that a witness has provided inconsistent statements and that their grand jury testimony is also inconsistent with other statements that they made?
We don't know if the grand jury testimony is inconsistent. We have well-founded belief that it very well could be based on the fact that he's given multiple different statements to law enforcement in the deposition. And we would be amenable to a review of Your Honor to decide if he didn't give testimony, then that would be the end of it. If he did, then Your Honor could determine if there was inconsistent statements. We believe that the secrecy rules have been, he's a listed witness now, Your Honor, from the state. There's no, the rules of secrecy have been, they've been accomplished in this case. So, and the justice, we would argue, demands that if he's given inconsistent statements, we are given those statements so we can use those at trial if need be.
So this it's just one witness, is that correct?
Your Honor, this is a narrowly tailored request for one witness. There was according to the state's theory of the case and the discovery, there's only one other witness who was in the residence when this purportedly occurred. It's a minor. And he has given at least, I want to say, 6 different versions of the story. Hence the state's need to amend their aggregator list, which came forward with the last deposition. Each time he's talked to by law enforcement, the defense, or even the state, more evidence comes to light. And it's not just inconsistent evidence, it's more and more evidence as it keeps coming forward. All we're asking the court to do is under a limited, the statute allows the court in its discretion, and the statute specifically allows to ascertain whether or not a witness's statements are consistent with testimony.
Which, let me just stop you there for just a second, because you're almost about to make my point for me. This witness has given inconsistent statements already.
Correct, multiple.
So you already have inconsistent statements if the intent is to impeach the witness in front of the jury.
Correct.
You have no idea what he said at the grand jury or whether or not he even talked about this issue.
I don't even know if he testified in the grand jury.
Understand?
The whole motion could be moved.
We're getting ahead of ourselves because technically all the grand jury proceedings are secret, and I'm not at that point of putting the state on the spot just yet. But my question to you is, if the point is that this witness gave inconsistent statements, and you know that he gave inconsistent statements, then you already have those inconsistent statements that you can impeach the witness in front of the jury, correct?
Correct, I do.
The purpose of unsealing the grand jury testimony, you want me to do an in-camera review to see what, if anything, he said about those issues, or I guess everything.
Correct.
So you can then see if you have another inconsistent statement that you can impeach him with.
Precisely.
But you already have an inconsistent statement, and the purpose of an inconsistent statement is impeachment, and you can already impeach the witness in front of the jury. So my question to you is, because of the secrecy surrounding a grand jury, why is it that I should unseal grand jury testimony so that you have one more thing to impeach somebody in front of a jury?
Because Mr. Solis has a Sixth Amendment and Article 1, Section 16, and then under the Florida Constitution to impeach all witnesses against him.
But you just acknowledged that you already can impeach him. Remember, the impeachment is not the contents of the prior statement. The impeachment is the acknowledgement in front of the jury that he said something that's different, which it sounds like you already have.
We do. the foundational requirements for the court to do that have been met because we've demonstrated that he's done that. All we're asking the court to do is a limited in-camera review of one witness, and he could have said things on other issues we don't even know about before the grand jury. So we're asking the court for a limited inquiry on that basis.
All right, Mr. Schrager, let me just pause my discussion with Mr. Crawford for a second. This witness that we're talking about, you're familiar with who it is?
Yes, I can provide the court with a lot of information.
Are they going to testify in trials? It's the state's intention to call him as a witness?
Yes.
Okay. Go ahead before I ask you any questions about the grand jury. So there's something you think I need to know?
Sure. And the witness that we're talking about, last name escapes me, Evan, was 9 years old at the time that this offense occurred. And he testified, he was interviewed by law enforcement that's documented what the statements are. I believe there was even a video interview of this witness back close in time when the offense occurred. So roughly April, maybe into May of 2023. Those statements are documented. Mr. Crawford has access to them. They are what they are. He then testified at deposition. This actually plays somewhat into the motion you heard earlier. He testified at deposition on August 14th, I believe, of 2024. And he said the same things that he had said back when. So same statements, no difference. Then, a deposition only 2 or 3 witnesses later, we learned that he may have made different statements to that witness. And we heard about those statements, and we had the detective, we investigated with the witness, with Evan, who I think now might be 11, hey, tell us about the situation, and he then disclosed different statements that were more in line with what the other witness at deposition had told us. And that was, again, it's laid out in the motion that I ran in front of the court. So August 28th, we had that conversation. So now there is, for the first time, a new set of statements that is not contained in the police report or in the depositions. And we've agreed, without even coming before the court, that Mr. Crawford could do a new deposition of a child witness because there are new statements. So the court is seizing on the exact thing that the state would be arguing in regards to these statements is, if there was completely different statements that I was aware of by a witness that testified at grand jury, theoretically, I would disclose that or have a duty to disclose that. However, if they are statements that are just the same as other statements that were made, I do not have a duty to disclose that, and Mr. Crawford has already everything that he needs. And there is no indication, and I don't think there's been any suggestion, and Mr. Crawford hasn't made a suggestion, that this witness did testify at grand jury and testified to something different than any of the statements that we are now currently aware of. So
if I hear you correctly, his prior statements have allegedly remained consistent, and after a third party said, oh, this witness told me this, you went back and talked to the witness about that issue, and then he added additional information to his prior statement.
And there was a little bit of change, but yes, he was more forthcoming with the events that transpired that led to Mr. Cook's death.
Was the little bit of change anything material, or?
Absolutely.
Okay, well that's a different story. If the change is material, then that's... All right, so let me start here for just a second. The statute that allows me to review grand jury testimony is 905.27. Paragraph 1, they set forth a few different conditions or times when grand jury testimony can be unsealed. One is whether or not to see if the testimony is consistent with testimony before the court. Now, I suppose that could be a deposition, but that implies that there's already been testimony before a court, separate and apart from the grand jury. Grand jury is not before a court, it's before a grand jury. The court's not involved other than signing the true bill. But I suppose that could apply. B, to determine whether the person is guilty of perjury. Now, it doesn't sound like, well, here's the thing. If the witness was asked a question in front of the grand jury and said something, and then later on asked the same question and said something different, that could be perjury. That could also be perjury before the grand jury. But based upon Mr. Sarabia's representations, it doesn't sound like it's at the degree of perjury. It sounds like the witness is just, and I'm not saying what I'm about to say to suggest that he's embellishing, but it sounds like the witness is just adding more to the story.
So I suspect when there's a second deposition taken by Mr. Crawford, that the first deposition and the second deposition will be able to be compared. And at that point, it would be easier for the court to understand, like without laying out all the testimony, it would be difficult for the court to understand. Because again, we are talking with a witness who was 9 and was then 11 in August of last year. He might maybe 12 now, but I think he's still 11.
Hold on a second. The last basis that I can disclose grand jury testimony is the furthering of justice or the public interest. And I don't know based upon what I've heard that we're there yet.
And I do have case law for the court, which I suspect the court is already aware of since the court has been more or less in line with that, but I would say Brookings v. State, 495 Southern 2nd, 135. In particular, the court says, what we find here, as we did in Jen, that appellant's counsel, through cross-examination at trial of both Lowry and Nelms, was able to direct the jury's attention to any purported inconsistencies between the witness's trial testimony and their prior depositions and other testimony, thus obviating any need for resort to the grand jury testimony. And I'd also cite Evans v. State.
Your Honor, can we have copies of the case law the state's relying upon?
I got a copy of Brookings.
Sure. He's paraphrasing what I've basically been, or I should say I'm paraphrasing what he is basically saying. But I'll let Mr. Sarabia, I'll let you put the rest of your cases on the record.
Evans v. State, which is 808 Southern 2nd, 92, specifically page 102. It says the same thing, I think cites Brookings. And that's a Florida Supreme Court case. And then Gosiminsky, which I'm going to spell Gosciminski versus State, which is 132 Southern 3rd, 678, 2013, Supreme Court Florida case. And again, Judge, the issue that I think the defense runs up against here, in addition to all the others that the public policy behind not concealing grand jury testimony, is they have statements in position A. And however different statements may now be in position B, they can impeach the witness with the statements from position A, which were consistent across position A, and there's no indication that they changed or would have changed if the witness did in fact testify at grand jury. And if there was, hypothetically, a position C, a grand jury testimony where this witness testified that was different than either of the statements, that would be something that we would have to disclose and we would disclose.
Well, here's what we're going to do. Not so we don't belabor the point. On this one, I'm denying it without prejudice. I will allow you to redepose the witness on this issue. Now, depending upon what the witness says, if you think that it is still necessary, you can always refile the motion, and then I can consider it. And in that circumstance, what I may be inclined to do, I'm obviously not making a ruling in advance, is review the grand jury the testimony in camera with the depositions, because again, there's two different things, okay? An impeachment is simply you kept somebody saying something different, but it has to be something that's material. Now, the state already conceded that what's added or changed is material, so I don't really need to make a finding. I mean, if the issue was the color of somebody's clothing, that's not necessarily material. If the issue was the color of a traffic light in a crash, that would be material. If it's just ancillary details that would be collateral to the primary issue, meaning, you know, you get the witness and they say something, and you admit that they said something different previously, but it's impeachment on a collateral issue. The case law even says that you don't get to impeach on collateral issues. I'm not making a finding of materiality now. I'm just kind of talking out loud. But the issue is if you can already either A, impeach the witness, or B, show in front of the jury that the witness's statements have changed or evolved. You have whatever they said to the cops, which presumably occurred before the grand jury. You have whatever they said later on, or in a different interview. You have the depo. You're going to have a second depo. You have this third-party witness. If the witness acknowledges that they gave prior statements, then they have been impeached, and you have impeached them in front of the jury. The fact that they may have said something that was consistent with what they told the cops, but inconsistent with what, or changed, or not the same as what they told in their second depo, I don't know that you get any more mileage or any more entitlement to it. Hold on one second. The other thing is, I forgot the other thing. So go ahead, Mr. Crawford, while I'm thinking about the other thing.
Your Honor, I just want to make the record clear. The state basically said that, look, he changed one thing, or a couple of important things. I would beg to differ with that interpretation. You have a minor who was originally interviewed with law enforcement who said he really didn't hear anything, he was playing a video game in another room, okay? That's what he said to the law enforcement when they initially investigated. In fact, during his first statement to law enforcement, the lead detective and the mother of the child said, tell the truth to the detective.
And later on he said something different.
Well,
yes,
but just to make the record clear, he went from saying, I didn't see anything, to saying details how the murder happened over 5 or 6 statements.
And you get to bring that up in front of the jury, so you can already impeach the witness in front of the jury. So my question is, unless it somehow vitiates the finding of probable cause, the fact that we're talking, and let's also not, try not to lose sight of the fact that we're talking about a child here, okay? So and I'm not saying one way or the other, but there's a big difference between a child saying, making something up or completely changing their story because it's a fabrication, and another thing because the child either remembered something or had something remembered for them. But you will still be allowed to explore all of that in front of the jury. Now, I'm going to pause for just a second and say that obviously nobody knows what was said in front of the grand jury. Mr. Sarabia has just represented that if he believed that this was perjured testimony, he would let you know, probably not call this witness or address this in some other way. I'm not suggesting, Mr. Crawford, based upon your facial expression, that you should rely on the representation from the state. Okay. But we started this, I think it was Mr. Petridis, who said you really don't know whether or not he did perjure himself or said something different in front of the grand jury. You just want to see. So again, I understand we can start with an in camera and it's me, but this is not a case where the witness said something to the grand jury and then completely changes their story later. This is a story, there may be different testimony, but you already have them impeached. Now, again, I don't know whether or not there's an explanation. I don't know if this child gave a reason or a basis for it. The added information, I don't know because I don't have the benefit of the deposition transcript. I didn't review that before this hearing. But what I'm saying is, based upon, if the reason is so you can impeach him in front of the jury at trial, you've already got that. And I don't know that we need to disclose grand jury testimony just so that you can find an additional reason or basis to impeach them. I mean, presumably this child or this witness is going to acknowledge that, yes, they told the cops that they didn't hear anything because they were playing video games initially. If not, that's a different story. So I don't want to keep talking in circles. I'm denying it without prejudice.
Yes, sir.
I'll let you redepose the child, the witness. After that deposition, if you think it is still necessary, I'll let you refile the motion and I can readdress it then.
Yes, sir.
All right. Fifth motion is, this one is filed October 22nd. It's a motion to declare the cold calculating and the CCP. took my shorthand. Anyways, unconstitutional. The first one that's filed October 22nd. Now, I just granted that, so this was a preemptive motion. Fair to say?
I'm sorry.
You all filed this one in anticipation just in case I granted?
Yes.
Okay. So it's now right because it wasn't right before. Just history of the case. My August 19th, 2024 order, we addressed similar motions, and I denied the defendant's request to declare 921.141 paragraph 8, 921.141 paragraph, I think it was G6, G and H, 6B, and 6A unconstitutional. You're now requesting me to find 6I unconstitutional, and it seems like it's basically the same grounds and the same argument, but now that 6I is on the table, you're moving to have that one declared unconstitutional for the same basis.
It's similar basis, Judge. It's a little more specific only due to, like you said, CC, cold calculated and premeditated. So I won't just rehash what's in the motion because it's a well-written motion, but just obviously there's a heightened standard due process for death penalty case. And the argument here is that CCP is vague, that it's not a proper statutory construction the way it's being implemented. It's not a strict construction, and it was initially written for execution-style killings, and now it's no longer even close to that. It's used for everything. It doesn't have a narrowing function, which is supposed to be the function for death penalty cases. And so based on that, we believe it violates Article 1, Section 9, 16, 7, 21, 22, and the U.S. Constitution's 5, 6, 8, and 14.
All right. And do you have, aside from what you put in your motion, do you have any controlling authority that says, or that would extend to this specific factor as it's currently written, that it is unconstitutional?
Nothing outside of what we put in the motion, Your Honor.
Okay. Mr. Strabey, any argument that you want to make?
Just briefly, Judge, I would cite to Smith v. State, which was a 1982 Florida Supreme Court case, 424 Southern 2nd, 726, and page 733. Of course, as we reject the contention that paragraph 5I at the time is void for vagueness. So this exact issue has been ruled on and it's been well established.
Yeah, I'm going to make the same ruling that I made in my August 19th order after that hearing, that I'm unaware of any controlling authority. I don't think that it is vague, while I think the term that we use is super due process. You know, he's entitled to every opportunity, but I think that the statute, I believe the statute as written is legally sufficient, and I don't think that there's any authority that says, I'm aware of, outside of the argument that you're making in your motion, that it is unconstitutional or it is vague, and I don't believe that it is. So for item 5, I'm going to deny that. Then we've got what I have as 6, which I think is the third thing that was filed on October 22nd. It was the motion to declare, I think this is 6D, unconstitutional. Same issue as before, it wasn't right. I allowed the state to add that as an aggravator. You're now moving to have it declared unconstitutional. Anything you want to say or add that you didn't just argue for the last one or at our last hearing in August?
Very briefly, Your Honor. Just that an auto aggravator doesn't limit, in fact, it expands. We actually argue that felony murder doesn't necessarily need the premeditation, which again should be a factor, an important factor in determining death. And based on that and what's in the motion, we believe this violates the 5th, 6th, 8th, and 14th U.S. amendments in Article 1, Sections 9, 16, 17, 21, and 22.
All right. Anything that the state wants to be heard?
Judge, I would just cite to this exact issue was dealt with in Menendez v. State, which is a 1982 case, 419 Southern 2nd, 312, and specifically end of page 314, beginning of 315. The court details his argument and says, we reject these arguments as being without merit. And then again, Clark v. State, 443 Southern 2nd, 973, which is also a Supreme Court Florida case, 1983. And again, right at the end of the case, page 978, The court said we have considered, again, summarizing the same argument that the defense has set out in the motion, we have considered and rejected arguments substantially the same as these in Menendez and White, and constitutional attacks are no more persuasive in conjunction with the facts of the Clark's case. So this issue is also well settled and against them.
Could you read that last sentence for the court reporter? I think she had a hard time hearing it. Just the last sentence of the case.
The constitutional attacks are no more persuasive in conjunction with the facts of Clark's case.
All right. Same ruling. I reviewed the case law. I haven't found anything that's controlling. I read the statute. I don't think that it's vague or impermissible. I don't believe that it's unconstitutional. So I'm going to deny this one as well. All right. Then the last one that we have, which is the motion to declare the death penalty unconstitutional and a motion in limine to preclude the minimization of the jury roll. Now, this was filed on October 22nd, but I think it's actually the second thing that's filed that day, or at least that's the way that it's docketed. Now, I previously addressed the constitutionality of Florida's death penalty scheme. This seems a little bit different, and if I'm reading the motion correctly, it seems that the issue is that you take issue with the fact that the jury only makes a recommendation, and it's the judge who imposes the final sentence. Is that?
It's similar to that, in the same vein, but it's that the jury is told essentially that if they make a life recommendation, it's fine, or if they make a death recommendation, that the court, which can overturn that and give a life. So basically taking it's not a final recommendation, it's minimizing what their job is there to do, so it's making it less important for them to find, they're not as worried about imposing the death penalty because they believe that the court is the last step. So it's minimizing their burden, what they're supposed to do, and we believe that is unconstitutional. We would like the court to have a motion in limine on that subject to tell them that their role is not minimized, and if they seek death, that they should be prepared that death will be given.
So, if I hear what you're saying, what the objection is that me as the judge tells the jury the state of the law in the state of Florida, that if you recommend life, I impose life. If you recommend death, I get to decide, and I can impose death or overrule you and impose life because you believe that somehow will, in the jury's mind, I guess, negates because they know that no matter what they do, I get the final say?
Yes, Your Honor. It's more of it's Caldwell versus Mississippi, which is 472 U.S. 320, which basically says that it's the United States Supreme Court decision that says that the state or the government cannot minimize their role as sentencers when it comes to the death penalty. And so basically, if you just tell the jury, oh, your death recommendation is just a recommendation, that minimizes their role, as opposed to saying, hey, if you recommend life, I have to impose life. If you tell them, this is just a recommendation to the court, that minimizes their role and how serious their role is.
But, well, let me back up for a second. You're not objecting to the hybrid format that we have, meaning they make the decision and I impose the sentence. Are you?
No.
Okay, because there's case law that says, and for the record, it's Grimm, G-R-I-M, versus Secretary, Florida Department of Corrections. It's actually a 11th Circuit case. It's 705 Federal 3rd 1284. The gist of it, that one says that the hybrid model is okay. So my question then becomes, my follow-up question is, if you're okay with the hybrid model, you're not okay with me telling the jury that we have a hybrid model?
No. My problem is telling the jury who ultimately does make the determination of life or death that what they decide is merely just a recommendation. Because in their minds, that leaves them, it's not as serious a decision as it really should be.
Right, so your objection is not with the hybrid system, your objection is with me telling the jury that we have a hybrid system.
That's not what I'm saying at all, Judge.
So I might be, that I don't think I'm understanding this one, and I'm trying to understand. What I hear you saying is, because I tell the jury that if they recommend death, I still get to decide what the sentence is, that I'm somehow, I'm putting air quotes, that I'm minimizing their decision because I can overrule their decision.
If the jury is told that the decision, again, the Caldwell case basically says that both the state specifically cannot minimize the jury's role in making a life or death decision. Our objection to this is by merely calling it a recommendation that undermines the importance of the jury's role in sentencing.
So the issue is with the semantics that I'm using. So if I take away the word quote-unquote recommendation,
correct,
and I simply tell the jury, ladies and gentlemen, at the end of, and I'm paraphrasing, at the end of this phase, you're going to go in the back, you're going to deliberate, you're going to render a verdict, and if you make a find, we're going to give them a verdict form and they're going to check a box. If you find that the defendant should be put to death, or if you find that the defendant should serve the rest of his natural life in prison, then I will impose a life sentence. If you find that the defendant should be put to death, then I get to decide whether he should be put to death or whether he should serve life in prison. And I take out the word quote-unquote recommendation.
No, that makes it worse.
But my point is, and this is what I'm trying to get to. I think I understand what you're saying. We in the state of Florida have a quote-unquote hybrid system for capital punishment. The jury does make only a recommendation. Well, that's not entirely true. If they recommend life, that's it. Right? I can't overrule that. So it's not so much a recommendation, but if they recommend death, then I get to decide. Now, please keep in mind, even though a jury's not told, if I impose death, then I know that you all know this, what's the next hearing that we would have after I impose death?
Spencer hearing.
We have a Spencer here, where you get to present additional mitigation, and then I get to decide whether or not I'm actually going to impose life or death. We clearly don't tell the jury that, but we do have not only a hybrid system, but we have a hybrid system where we give the defendant the proverbial second bite at the apple to present mitigation, so that the court could still impose a life sentence. So what it seems to me is that the issue is, by actually telling the jury the state of the law, you are of the opinion that we are somehow minimizing the decision that they make, because we tell them that regardless of what they decide, the ultimate decision is mine.
Correct.
Got it.
Exactly.
Mr. Schraby, anything that the state wants to say on this one? You don't have to. I'm just giving you a chance.
I would just say, Mr. Patridas kept using the words minimize, but then accurately describing the system in the state of Florida, which is not minimizing. That is describing. Minimizing. In the Caldwell case, I was just looking at, because I've read this case a while ago, I believe that in that case, the prosecutor specifically said something to the effect of, if you make a decision, don't worry, the appellate court can just fix it, kind of implying that, it's not final when it wasn't an accurate statement of the law there, or it did minimize the import of their decision. But the fact that, and in terms of this argument, the defense, as written, they're asking for a couple different things. And one is to declare the statute unconstitutional because the statute minimizes the role, which I think it actually elevates the role from the previous system that we had, because if the jury decides life, then it's life. There's no minimization of that role. So I think that the motion as written should be denied. In terms of the motion in limine, the state has no intention of minimizing the jury's role, but I think that the jury should not be lied to about what the state of the law is and what their role in the process is, and in an attempt to aggrandize their role. So, as Mr. Petrides described it, which I think we all agree is their role, if they make a decision and they decide life, then it's life, that's the end of it, no ifs, ands, or buts. If they decide death, then the court then has to make a ruling, life or death, which is an accurate statement. I don't think that that's wrong, and I think it is the way that the process should be done. I think the jury needs to know that. Otherwise, we're not accurately describing it. There's no minimization that's occurring. Minimization would be if we told them, your decision here doesn't matter at all. And it's harder to do that now because of the current scheme that we are in.
All right, so let's start here. I understand the argument, and I think that, and I know, Mr. Crawford, I wasn't trying to box you in, but ultimately the issue is with the word, with semantics, with the word quote-unquote recommendation. But I don't think there's any way to articulate it or to change it, to take out the word recommendation to fix or cure the issue that you see. Hold on a second, because jury instructions that are given to a jury have to be an accurate statement of the law, and they have to not be confusing. Now, a long time ago, the powers that be decided that we should tell a jury that even if they do make a recommendation of death or vote for death, that ultimately the final decision rests with the trial court. We tell them in every other case that's non-capital, we read to the jury a standard instruction that says they shouldn't consider the sentence because sentencing is up to the judge. In fact, I think we even tell them that in voir dire. If we don't, it's not a standard instruction, we read it to them, but it's in one of the standard jury instructions in 3. I don't remember if it's rules for deliberation or weighing the evidence. It's one of those. Anyway, so the standard instruction, and I'm looking at it now, it's 3.12e is the quote-unquote jury verdict form for the penalty phase. So the standard verdict form says, we, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether the defendant should be sentenced to life in prison without the possibility of parole or death. That's their options for the verdict form. Now, the fact that we might tell them that we have a hybrid system, in my opinion, is an accurate statement of the law. It's akin, in my opinion, I'm not saying it's equal, but similar to us reminding juries that they shouldn't consider a defendant's right to remain silent as any kind of admission or acknowledgement of guilt, because it's a fundamental constitutional right. We tell them all kinds of other things that normally would have nothing to do with anything, to make sure that they know. But it shouldn't weigh into their decision. If it does, then that's up to each individual juror. But I don't see the issue, and I don't believe that it is, quote-unquote, minimizing the jury's role by simply telling them that you're going to make a verdict, and it's life imprisonment or it's death. And if it's death, I get to have the final say on whether it's death or life.
The standard instruction, as it's read, says that recommendation has to be given great weight by the trial court. The point of the motion is so the state doesn't just argue to the jury, this is just a recommendation.
I'll fix that for you right now. If the argument is, or the motion is that the state can't argue to the jury that your decision doesn't matter because it's my say, this is only a recommendation, I'll agree that you're not saying that.
I agree with that as well.
Okay, so the state cannot argue to the jury.
And I can only fight the motion that they write.
I understand. I'll say this, we're going to talk a lot about it when we death qualify this jury anyway, which, by the way, is one thing that is different from death penalty cases, is that we get to qualify the people who sit based on that one specific issue. So I'll agree that the state may not argue to the jury in the penalty phase, the penalty phase, that their verdict is only, quotes, a recommendation. There we go. Anything else on this one?
No, Your Honor. We'll reserve the balance and renew it as argued within the motion itself.
That's fine. And I'm going to do a very brief written order. It'll kind of be along the lines of my last one, where it simply identifies the motion and gives my ruling. That way there is a written order for you in case you want to do anything with it. Now, it's 4:45, I do actually have some other hearings. Is there anything that we have to address today?
I don't believe so, Judge. With the court's order of the juror questionnaire, Mr. Sarabian, I spoke with that earlier today. We have a draft going. The order didn't specify what you wanted and what subjects to address in the juror questionnaire. I assumed, based on what you put about the individual voir dire, that it would be hardship, death penalty, pretrial publicity. For the three things. I put some extra things in there in case we want to put those in to help the jury selection process, but I wanted to see if that's what the court wanted in the agreed upon jury questionnaire which we're working on.
Yeah, those are my intentions, the big ones. I have to find my order. I don't remember when I wrote that one. Was that one in?
It was an omnibus order that the court issued on August the 19th, 2024.
There's a lot of stuff in the docket.
There is.
All right.
It's on page 7 and 10 of your Honor's order.
I think that we were going to just do the big ones in the questionnaire because that we were going to break them down into groups.
When you say big ones, it would be those three topics?
Right.
Okay.
Right. Those are the main issues. I mean,
And the small groups are paragraph C, which is on page 7 of 10. It's the last.
yeah, I thought that I wrote something. The problem with these omnibus orders is I have to go through the whole thing. Alright, I don't see where I talked about. Yeah, we were gonna have them come in. We were going to the length of the trial, nature of the charges, any familiarity with you. If you all want to add extra things into that questionnaire that they're going to fill out, that's okay. We're gonna have they're bringing in 500 people. We'll see how many actually show up. We're gonna break them up into groups. We're gonna stagger that group into I think about 50 at a time. I'm just reading here. And then we're going to bring in around 20 so that we can address the big topic issues. So yeah, if you wanted them to have a questionnaire in advance about those big topic issues so that you could talk to them and we could know, that's fine. If you want to add extra things into the questionnaire, if you all agree, that's fine. It's an agreed upon questionnaire.
And can we have that questionnaire filled out before we question them
in here?
Yes.
That's the plan, I think.
Okay, great.
Okay. Mr. Strady, anything else on behalf of the state? Mr. Solis, anything you think I need to know or address today? No, sir. All right, the next time we're going to have you in front of me is going to be for your Arthur hearing. That's in March. It's about 6 weeks. Well, the calendar page. But obviously, if something comes up, your lawyers know how to get in touch with me, and we'll bring you back. Then I'm trying not to set anything. I got it set at 10. I'm trying to keep my morning docket very, very small so we can roll right into it. I'm going to also say real quick with that, whatever you all want me to consider, you're publishing in the hearing. I don't want hours of footage that you all expect me to go back and watch on my own and then make a ruling. Whatever evidence you want me to consider, we're publishing here.
Yes, sir.
Okay. All right. Thank you, everybody. For digital, we're going to go back to you in just a minute.
All right, so you heard him say the Arthur hearing was going to be in March, and that was supposed to be today, but we can't find an actual stream. So if somebody does put that out, we'll go ahead and we'll stream it, because I do want to watch that, because that was the whole point of today. But we basically just kind of filled in time. So that was Oscar Solis. So I am now going to completely change gears, and we're going to take you over. We have Donna Adelson. Donica. I got Monica and Donna on the mind. All right, so Donna Adelson has a hearing today at 2:30 our time. So in the meantime, we're going to show the past. We're going to show her bond hearing and then her Alfred hearing. So I want to get those in before her actual hearing starts at 2:30. So I'm going to end this stream. I'm going to say thank you for watching. Thank you to Aaron, and thank you to our mods. Thank you for all the new chatters that showed up today. And thank you to those that are upping your monthly subscription, your membership. Appreciate it. So I'm going to end this. We're going to portal you over to Donna Adelson stream. She has a live hearing at 2:30 Eastern, but before that, we're going to show her past 2 hearings. So thank you guys for joining us today. I will see you in about, I think it starts at 11:30. So I'll see you in about 9 minutes over at the Donna Adelson stream. So until then, thanks for joining us. See you later. Bye.